Today's topic is purchase and sale agreements, which is kind of that, hopefully that logical next step after you've formed either a partnership or you're going to go at it alone or you have the equity capital loosely arranged. The next step is, we're submitting LOIs. I'm not going to go through that from a legal perspective because they're relatively simple documents, but let's assume that an LOI is accepted, it's signed, and now the next stage is PSA, purchase and sale agreement. So that's going to be tonight's topic, is talking about how to buy this land for your development. And I've got a nice little PowerPoint. So let's talk about purchase and sales agreements. This is a critical stage of development. I think that a lot of this is the first time that you have money involved in terms of earnest money is at risk. And so it's really critical that you understand what needs to occur or what needs to happen during the PSA and what can be handled after the fact, post-closing kind of obligations, because there are a certain number of things that will kill a site. And that is, we call that the deal breakers, things that you've sunk costs into this, but you absolutely don't want to move forward with this site, and you want to be able to have options to either get your earnest money back, maybe you can recover your due diligence costs. If it's something like a seller breach of a representation or warranty, you can actually get your attorney's fees, that sort of thing. But we're going to go through a purchase and sales agreement. It's going to be rather high level, and so it's not going to depend on whether you're using a promulgated form, like so NATCAR, North Texas Association of Realtors has a form contract that you can use for commercial property. It's also like a TREC. There's an unimproved land contract, and there's also a custom contract which an attorney may draft up. This conversation doesn't matter whether you use a promulgated form contract, that's 10, 12 pages, or if you use a custom contract and it's 50 pages. We're going to talk about, number one, essential clauses in industrial PSAs. So one of the very first important things that you have to understand is how do you describe the property? It's not just enough, because when you're dealing with raw land, and in particular something that's maybe out in the county, it's in the ETJ, maybe it's a smaller portion of a larger farm parcel. This has never been platted before. Maybe it has been platted, but you're buying 2 or 3 of the tracts and combining them. You've got to understand, what are you buying? And it's not enough to, just kind of point and say, well, you get all the land from this county road over to the tree, over to the pond, and back over to make a rectangle. That's not going to cut it. However, for land that is not platted in a subdivision, like, thinking about your house, thinking about a retail shopping center that's traded hands 15 times before, there are not good descriptions of the land. And so the alternative is basically, you have to describe, between you and your lawyer, what is the land you're going to buy. And so the common way is to get a surveyor, and you will do a meets and bounds description. Now, for purposes of your PSA or what your LOI, you are certainly free to go on Google Maps and literally just trace an outline. That is totally fine. You can do the measurements, you can get the square footage. That is totally fine for LOI. But when you're in the PSA, you now need to describe the land particularly. And there's a couple different ways you can do that. One is to have a surveyor do, call an ALTA survey, but he's going to need to know what the boundaries are. And so it's sometimes a chicken and the egg. You have to describe what you want to carve out to him, and then he can draft a meets and bounds description. So the meets and bounds description, starting at a point fixed as an iron rod. And so the surveyors have these pins. They will mark the pins into the ground. It will be a known point that is supposed to be fixed, and they're not supposed to be moved. It's like a state crime if you move surveyor marked pins. But they're an iron rebar rod, and he'll find it and it'll have a number on it. And they say, starting at this point, we will measure a distance of 550 feet due east at a degree of 91 degrees east northeast, and mark over to this point after 550 feet. From that 550 feet, we turn south I don't know, south and go down 200 feet. From there, you turn a bearing of, 32 degrees south, southeast, head that way for 700 feet, and then you have to trace back to make a polygon. You have to trace back your shape. Now, it's easy if it's a rectangle or a square, right? Because you typically have call outs that are north. You'll have call outs that go east, a call out that goes south, and a call out that goes back west. And it should end up at that back point. But the surveyor is the only one who knows how to speak this language and can draft the meets and bounds description accurately. And you're going to need that. So it's a little bit of a chicken and the egg, but you need that in the very early parts of the contract because that's going to what's describing your land. Of course, you can use acreage. You can say, 8 acres or 4 acres here, but that still doesn't tell you exactly where your land and where your boundary is. So that's what the surveyor comes in. And, again, these are all properties that we're not going to have a street address. So just throw that out the window. That's not going to be useful here. And that wouldn't count as a legal description anyway, is a street address. You can't call it 123 Main Street. Certainly not for raw land like this because they don't have an address. They don't have a postal box. They can't receive mail. They don't have that assigned to them. And so 123 Main Street doesn't mean anything in terms of the PSA. So that's the first thing, is describing it. And if you contract with the seller at call it a price per square foot, there is an area that you can check. This is an essential clause. You say, if the area of the land that we've described, again, drawing your rectangle or marking it to a tree or something like that, if it's less than 4 acres, I get a pro rata price reduction. So let me just say that again. You have the ability in your contract that if you're contracting for a price per square foot, but the survey produces a area that is, call it 3.9 acres, you get a pro rata reduction in your price. You're not necessarily paying, call it 500,000 or 400,000, right? 100,000 an acre. If it's only 3.9 acres, you only pay 390. And so you can understand that's a decent difference, that if you're getting less land, you should pay a lower price. And it's totally logical, but it's not necessarily the default, and it's not necessarily what's in your contract. Because certainly the seller says, well, I intended to sell you 3.9. I wanted my price of 400,000. There's no discount. So that's the seller's incentives. But you as a buyer have this incentive to it the opposite. So it's a little bit of a zero-sum game. And I'm not saying what is right or wrong. You just need to know going into the contract which scenario you want to enforce. Again, so that's talking about purchase price. Coming up with the value, it's a relatively straightforward, but how you pay the purchase price, it's going to come in different segments. So we have earnest money, and especially for land where you may need to get some type of a zoning change, or if you want to get a site plan approved before you close, you will have the purchase price broken down into a lot of deposits, a lot of additional earnest money. And it can be a little bit complicated with land because you have a longer due diligence period. We're talking like 90, 120. I don't know exactly what Hamza recommends, but you do have a longer due diligence period than other types of commercial real estate, other industrial. And so what you might need to do to entice the seller is to say, okay, we're going to put 30 grand down, initial earnest money that's fully refundable. After 30 days, after 60 days, that 30 grand becomes non-refundable. And if you want an additional 30-day extension, you have to put another $10,000 down. And after 15 days, then that money becomes non-refundable, and so on and so forth. So it can get very complicated, but the key idea is to use deposits and use incremental hard money deposits as a tool that you can extend until you have to pay the full purchase price in cash. And so that's either cash or you have a loan closing, but a lot of lenders are delaying closings right now. And so it's critical that you have baked into your PSA automatic extensions for additional deposits. And most sellers are pretty reasonable, but you're going to have to put money down in order to extend the actual closing. And so that's something that we put in, I would say almost every contract, is you say you want a 15 or a 30-day extension of closing for X amount of dollars that goes hard, gets released to the seller. It's attributable to the purchase price. So 400,000, you put 30,000 earnest money, you got 10,000 extension. And if you want another extension, you have another 10,000 that goes hard. You have a total of $50,000 towards the purchase price. It's not like it's a fee, but that's really critical so that you can control the incremental risk as you proceed with your due diligence on the property, because some of these reports, some of these answers from the city, they're going to take a long time. And if the city says no, you can't build certain density or a certain layout that you want, you don't want to build you don't want to buy the land. You're willing to walk away from, say, even an earnest money deposit, because in the alternative, you're left with a piece of land that you can't build on profitably. And so that's really critical that you understand those tools to extend closing. Let's talk about two of the major due diligence areas. Environmental assessment, which is a phase one ESA. Guys, check out my YouTube channel. I have a lot of videos about phase one ESA, kind of walking you through an actual report, as well as going on site. And I walk around with the, I don't know, the engineer who's conducting the actual phase one. And so it's kind of cool. We had some dialogue. So check out that YouTube video, phase one ESA walkthrough. And these are critical because, again, if you're buying an existing piece of land that has tenants, if there's users on there, there absolutely could be environmental risks of petroleum products. We're talking oil, antifreeze. There can be underground storage tanks, USTs, that are very expensive to remediate. And we can be talking about leaks of hundreds of thousands of gallons of fuel, of paint thinner, different types of caustic chemicals that will cost you money to remediate. Your lender may not lend if it is a contaminated site. And so environmental is really critical if you have these quote unquote like dirty sites. So if you see junked cars, if you see tires, if you see drums, 55-gallon drums on site, if they're hidden, if they're covered under brush, that is a red flag that you still may be able to buy the site, but you need to understand you need the rights to conduct a phase one. You need to order it. You need to force the seller to give you any actual knowledge of environmental violations, any environmental notices. So if you're in Texas, we have the TCEQ. You may have EPA notices, but the PSA must require the seller to disclose any information about environmental violations or potential violations, alleged violations, that sort of thing. So phase one, that's critical that you have that in the PSA. Zoning and regulatory compliance, and again, another huge area for you guys as building. If this is raw land, it doesn't have any prior grandfathered use, you probably wouldn't buy this land if you can't build your flex product on top. And so understanding the zoning and making sure that your product is classified correctly as a matter of right. And what I mean is there's two different types of uses that we like to look at. And that is zoning either by matter of right or permissive zoning, like a conditional use permit or special use permit. I know you guys have talked about that before, but you need time. And oftentimes we don't necessarily confirm this until after we're under contract. You need to confirm what the uses are, because your building may be approved, but the tenants that you're looking at leasing to, their use may not be approved. So again, I'll give you a quick example. You find a nice piece of land, the zoning is good for industrial, it's got industrial around it, but this is farmland, it's never been before. And your goal is to lease it out to automotive users, auto body repair, a paint shop, that sort of thing, parking, maybe a automotive mechanic, somebody that fixes broken cars. But you may not have that use as a matter of right. You may apply for a conditional use permit, and now you've got all these tenants who come into your nice brand new building and they're trying to apply for a permit and they get shut down. it puts your lease, it puts all of your financials in a whack of what do we do when the tenant's business gets shut down because they don't have a use permit and it's going to take 6 months for them to apply for it. And I'll tell you, the city doesn't like it when you do something first and apply for permission later. If they have a subjective analysis, they don't like it when you've broken the rules and then later are forced to apply for a favor. That's essentially what you're doing for conditional use. If it's a use by right, I can come in here guns blazing and I can do the thing. I can run a auto recovery salvage yard because if it's permitted by right, I basically just apply and they just rubber stamp it. If I have a conditional use permit, if I have a supplemental use permit, I have to apply and say, "Oh, hello, city. I'm going to run a sand blasting operation, but I'll be very clean. I'm going to be very quiet. We're not adjacent to any residential neighborhoods. I have all the latest technology. I have all this great equipment. Please approve my special permission." And then the city can decide yes or no to give you this permission. But that allows them to do a lot of overlays. They can require additional equipment or like a fence or a taller fence or different filters or all sorts of different requirements if you're applying for a special use or conditional use permit. So really critical that you have enough time to get sufficient answers from the city about what you want to do in terms of the zoning and the use. So let's go down to contingencies, the other half, inspection needs. I think this is pretty easy. There's a broad category, but there will be some sellers that are very particular about who gets to go onto their property. You have to get permission. The seller has the right to accompany these inspectors, but at the end of the day, you just want to make sure that you have a short window periods of notice, like a 24-hour written notice to the seller that, hey, this inspector is going to come on site, this surveyor is going to come on site, and they're generally going to be okay with it. But you just don't want to trip any clauses that puts you in a bad position vis-a-vis the seller. You don't want to be violating any clause of the PSA, but you as a buyer need to make sure that you're protected and you can do whatever inspections you need almost any time of day that you need to. Financing contingency. It's something that we haven't seen in the past 3, 4, 5 years in industrial, but it is coming back. I've seen a couple of contracts that I've done recently that do have a contingency for finance approval. And we have to be very specific about what does it mean. From a seller's perspective, we want to pin the bank down into a very clear yes or no decision. If you're a buyer, you want to make it more permissive that just says, lender approval of a loan not to exceed, 70% of LTV at an interest rate no greater than 10%. Because if the bank is willing to lend at 9%, that doesn't kill the whole financing contingency. So we want to put some specifics. If you want the seller to agree to a financing contingency, he has to have a reasonable expectation that these are reasonable market terms that we could expect a lender to extend financing to. But we do see them. So if that's an issue for you guys, definitely put it in your contract that you have a out, even if it's 10 days before closing. If your lender pulls out, you as the buyer get to pull out and you get your earnest money back. That's really critical. The regulatory approval process, we kind of talked about that earlier, but some people, depending on how large your project is, or if you're trying to go for a zoning change, you will have the full administrative process until you get a zoning change approved, then you can close. And so, we may not see that for your guys' deals, depending on the size. But if you're going for a zoning change, you'll say in your contract, this due diligence period does not expire until the earlier of 180 days or the approval of a zoning change. So then you tie up the land for months, if not years. Representations and warranties. So this is a great section. I think it's critical when you're dealing with some type of site that maybe has an existing building on it and you're building on the back. Maybe this guy used it as a truck yard or some other type of use. you want to pin the seller down to certain representations and warranties that they did not do something bad to the site. They were not exactly aware of something. There's no pending lawsuits, no litigation, condemnation. And again, these are fairly standard. I don't know off the top of my head how many are covered in a lot of the promulgated forms, but I will say it's some, but not all. So if you do a custom contract, we're going to put the full kitchen sink of representations, full kitchen list, the grocery list of representations and warranties, because we want to see what sticks and we want to see if the seller can pick and choose some of those to decline, no problem. But we want to put the full list and see if you can get those representations from the seller, because they know a whole heck of a lot more about the property than you do. And we want to make sure that we get the benefit of their knowledge. Again, those are the two major pieces: property condition and operational history. You know, we really want to know, was this used as a junkyard? Was this used as an oil recycling plant? Was this used as a smelting, aluminum ore smelting? 50 years ago, maybe more than that, 80 years ago, was this used for iron ore smelting? I don't know, but the seller might. He might have actual knowledge of that. Even if he wasn't alive or if he didn't own it, he may have knowledge. Title and survey, again, we talked about this, but a lot of people don't understand the purpose of a title commitment and what we do as lawyers when we file, say, a title objection letter. So in essence, when you buy a title policy, the insurance company is underwriting and giving you a policy for your piece of dirt, your rectangle, and saying you have free and clear title to this. You own it 100%, no liens, no easements, no charges, no fines, any of that stuff. And if somebody comes up out of the woodwork and says, actually, oh, surprise, I own this land, I have a claim to the title, and if they end up being right, if they win that claim, that allegation after you've bought it, the title company, if they've insured you, they will pay you out your purchase price. And it doesn't really compensate for your loss of time and other expenses, but at least you get something back. You get the big bulk, which is your purchase price back, if they missed something on title. However, that's the extreme scenario. What is much, much more likely and happens on every single deal is you get little hair on the deal. So instead of getting a very clean piece of rectangle title that just says you own this, fee simple, they will have what are called exceptions. And so they will pull everything that was filed around this property for years and years, and they'll have, say, some easement from the natural gas company or electric company. Electric easements are more common. And it doesn't affect your property because, again, if you remember in my example, we carved this 4 acres out of, say, a 40-acre tract, that farmland that this guy owned before. And so the farmer agreed to grant easements all across his property, running to different neighbors, running to his own house, running parallel to the road, that sort of thing. But they all come up on a title objection, and it causes a lot of confusion if you're trying to file a claim later when the electric company comes and wants to put an easement right down the middle of your 4 acres. And you say, whoa, no, you cannot build on this because I had an Alta survey done. There was no recorded easement. Every electric easement that we pulled was only around the perimeter of my property, say like along the road and, back on the back 8 acres, but not affecting my parcel. And the title objection is the paper representation. It's like a legal list, and the survey is like a picture, is a graphical depiction of the property, and the title objection is a verbal, a written depiction of the property. And so as your lawyer, we're going to compare the Alta survey against the title objection, the title exceptions, and strike the things that don't apply to your property. Because if you have an issue with the electric company down the road and they're trying to put a pipe, or they're trying to put a pole right down the middle, you need to be able to file a title claim to say, hey, there was no objection, no exception for this electric easement down the middle of my property. And so if the electric company ends up winning, you can get your money back. But if you don't if you don't push back on those policies, it's going to get very cluttered. And I'll tell you, if you've ever looked at one, they can be crazy. They can be 3 or 4 pages of exceptions just listed: gas easement, this electric easement, access easement, all sorts of different encumbrances on there. And so that's what you do. You want clean title that says it is sufficient that I can build the type of property that I want on my land without different easements crisscrossing the middle or right of ways prohibiting me from building my building. And that's what clear title means here. Accurate Alta surveys, we won't do a boundary survey. Maybe the seller may have a boundary survey, but you want to be ordering Alta surveys because that stands for the American Land Title Association. It's basically just a standard that includes a much higher level of detail. A boundary survey, as the name implies, just goes around the edges, and that's useful, but it's not that useful. And you need an Alta that will depict fences, that you can do bushes, topiary. So you can have a topiary schedule item that you put all the bushes and plants, and he'll do his best to like identify them. It's pretty cool. But that's what you want. You want an Alta survey so that you can really understand what is on your property. Environmental clauses. So I feel like I've kind of talked about this a lot. I kind of jumped the gun in talking about environmental liability, but it's absolutely critical that you have seller indemnification if after closing something environmental arises. You still want the seller, you want a cause of action to be able to sue the seller for environmental concerns. And I don't see this a lot on standard forms, but it's a great clause to put into your custom contract, is you want that seller to be liable after closing for anything environmental. Same for remediation, right? So environmental liability, reduction in value, or if you just have to remediate like this little GIF file, he's digging out dirt. Sometimes, or a lot of times, depending on the chemical, if there is a leach of chemical, all you have to do is scoop out all the dirt like this and backfill it with clean fill dirt. It's probably the least expensive way. Well, the least expensive way is just to dump a bunch of water. So there are certain chemicals that are water soluble, not petroleum based, not, maybe it's glycol based. Somebody's a chemist that they can correct me, but if it's like glycol based and they discover elevated levels, a approved method of remediation is just to pump a ton of groundwater all over it, and it dilutes the concentration of say a glycol based contaminant until it's at a sufficiently low threshold. I think that's the cheapest and easiest way. You just buy a bunch of water and just pump it all over the ground until it dilutes the contamination. But if it's dirt and if it's something like petroleum, you have to scoop it out. You have to like physically scoop out all the affected dirt. They'll test it again at the bottom of the pile, the bottom of the hole, and then you backfill with clean dirt, and you have to dispose of that oil, the contaminated dirt, properly. So, we're talking like maybe 100 grand, 150 grand if you have to remediate by scooping out the dirt and buying clean fill. But that's a cost that you shouldn't bear. That's not your fault as a buyer. You should hold the seller liable, and you should have a clause that if you have to incur this cost, you can go after the seller and sue them for that. Closing and possession clauses. These are, again, much more important, I think, when there's an existing use, there's a tenant on there, and maybe they say they're month to month, and you're like, okay, well, that's fine, but you need to give them notice, and the seller has to be the one to deliver possession of the property free of any other users. No personal property, nobody out there with a truck that says, I still have a lease, I'm month to month. And possession is really important so that you actually have access to the site and you can exclude others from the site at closing. So that's what closing and possession, it's fairly standard. Risk mitigation. This one's important in a very high level. I'll still talk about. I consider a contract to be kind of the ideal situation. And I will give you this, that is very academic. The contract is a theoretical world where everybody is perfect, everybody understands each other, we all shake hands, we put it on paper, we sign it. It is very abstract. And it has to be an important part of your strategy, though, to even start with an ideal level of clarity, because I can tell you that once you actually get into the deal and once you start moving earth and start hiring people and hiring vendors and buying stuff, it gets really messy really fast. The reality is, doing construction or value add or buying real estate is messy. And so your strategy, I think, should be what are the things that have a high expected value? If this occurs, what's the expected value? And so let's say it's like a 1% chance of $100,000 harm. If that's the case, you need to spend $1,000 or less to mitigate that type of behavior. I think it's very logical on some of the other ones. Let's say you're buying a $500,000 piece of dirt, there may be a 1% chance of a title claim. Well, you've got to spend $5,000 or less to mitigate that in terms of your risk mitigation strategy. And my whole purpose of this is just not to go into a contract blindly, and also don't assume that they're all the same and there's nothing I can do. You've got to understand what are your risks, and if the risk is acceptable without any type of protection. And again, I give you another story. If you're going to be operating a chainsaw and you don't want to wear eye protection, that is totally fine. I'm a lawyer. I can't protect you from little bits of wood flying at your eye. I can't guarantee that bits of wood won't hit your eye. But if you understand that those things are flying off at 200 miles an hour, and if it hits your eye, it could blind you, okay, fine. If you're aware of those risks, it's up to you as the owner to decide, I'm in such a big hurry. I need to cut this tree branch down right now. It doesn't matter if one of my eyes goes blind. That's a risk you have to take. But if you don't want to do that, there's a step you can take and buy some $10 eye protection and put the glasses on, and that will protect you against probably 99% of the flying pieces of wood. And that's exactly what I'm trying to say here, is that you can go into and you can buy land, and you can probably buy land 10 times and not have any issues. If you do good due diligence, if you know the sellers, or if you trust them and blah, 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 you have a system. But on that 10th time, if you lose something, what harm happens to you? What is your potential risk of loss? And again, people may tell me, like, Ron, the loss is very small. I'm buying a very cheap piece of dirt. I don't even want to spend anything on legal. That is fine too. You just have to understand what your expected value is. And I think spend the money to mitigate something that's below that expected value cost. So that's it for strategy, is just understand what the harm is, understand potentially what the risk, the percentage risk is, and that's your expected value. That's your expected outcome. Maybe spend some money less than that to mitigate that and ensure that doesn't happen. Personal investments. I've done a fair number of deals. This is actually one of my properties. This is 5.5 acres of M1 industrial in Haltom City, Texas. We're currently using it for truck parking. Yeah, it's got a 6,000 square foot building on it as well. But in this one, I I wasn't as sharp, and this is, again, full disclosure, this is as a lawyer. I wasn't as tight about making the seller liable for certain things that we discovered during due diligence. And I felt like if I had put automatic price reductions, so for example, just some outstanding permit, and then said if there's an outstanding permit, the seller has to pay to remedy. I think that's a lot more palatable if we put it in the contract and he's forced to pay unpaid balances, just like unpaid electric bills, something like that. If you force the seller to do that in the contract, of course, I could have had the option of terminating and retrading the price, but I didn't really want to blow up the deal over a few $100 or $1,000. But I would have gladly taken that money from the seller if it was in the PSA and he had an obligation to satisfy certain unpaid liens. So, well, they're not even liens, but they were unpaid, I would say, debts. unpaid invoices, something like that, but it's not even that strong. It's just somebody saying, oh, if you want to be in good standing, then you can pay this. So it wasn't a requirement. Nobody was bringing the hammer down, but it was, if you want this, then you need to pay. And I would have wished the seller would have paid. So a little bit less than, it's not a huge amount, but I definitely should have had that in the PSA. I have a free template. So for PSAs, for custom lawyer industrial PSAs, these are ones that I use. You can go on ACRE, Adventures in CRE. I know that Sean and Hamza like this website. So I'm actually a legal contributor there, but this is the modeling section. And I have a legal section where I have just a bunch of legal templates. So I am going to upload this PowerPoint. So this link, this little hyperlink down below does work, but Adventures in CRE, try to navigate. I know it's not super easy, but find the legal section, search for Rohde, search my last name or my first name. And I have a lot of legal documents that you can download for free on adventuresincre.com. And this below will be a direct link. So that's how you can get a custom PSA, and you can kind of look it over and noodle it and make changes or whatever you want to do. You do. Bye.
See you guys. Bye.